So what are the powers of this company secretary? And the powers and duties depend on the size and nature of the company, as well as the personal contractual arrangements that they have made. However, these are the general powers. These are the basic powers. That is to be present in all meetings and to take minutes of such proceedings, and to also issue notice of meetings to members and to others, to countersign instruments which the company seal has been affixed, to conduct and record transfer of shares, and to keep the books of company, especially those that relate to internal administration. And the reason they keep these books, specifically the share register and register of charges, you remember a transfer of a share is equal to transferring ownership. The legal implications of that, whereby you're no longer the owner and your title has transferred, they need to be kept and recorded because they affect your ability to transact with the company. And the company secretary will also issue these special resolutions that are to be set out. The special resolutions that talk about changing or altering the articles of association, those that talk about how to alter the capital without reducing the amount so given. And these are the differences in roles across public, listed, and private companies. So the roles of a company secretary include compliance with legal and regulatory frameworks. And that is one, filing annual returns. They ensure timely submission of annual returns, financial statements, and other statutory documents. We have talked about them maintaining a statutory register, keeping updated records of shareholders, directors, and all other registers. And they also adhere to the corporate governance practices. And the company must follow the best practices, including compliance with the Companies Act and all other relevant laws. They facilitate board meetings and shareholder communication. That is in preparing the agenda and the minutes, in communicating with the shareholders, the notice of the meetings, any other relevant information that the shareholder may require. The registered office, the number of shares held, the list of the directors, the list of the auditors, the list of the accountants that are authorized to look at their books of accounts. Company secretaries also have that strategic advisory role, and due to their background in law, they will advise on legal matters. That will mean compliance on matters set out in the Companies Act. And this will be about filing returns. How often do you file returns? In what format? Who can sign these documents? And they also support the strategic decisions of the company. And this is by providing relevant information and analysis. Again, we go back to their role, to their background, what they have studied, being members of certified bodies. They're given a duty of care to ensure that the information they present to the board members as well as the shareholders, one, is in compliance with the law. And if the law changes, they're the ones to inform the board of directors that we can no longer do ABCD because it is no longer legal in this country, or where we have been doing our business and the law has changed. Again, it is up to the company secretary to update the board of directors on the same, as well as the shareholders. And in doing so, they implement ethical policies, anti-corruption, corporate social responsibility. They ensure the company, the board of directors, the shareholders, they also take a role in giving back to the society. And that difference between law and morality, where something may be morally wrong, but legally it's acceptable, they try and find a balance to ensure that the company is not only appears good, but is actually doing good. So these differences in roles across public, listed, and private companies. In public companies, whose shares are traded on the stock exchange, such as the Nairobi Securities Exchange, company secretaries, they have also extensive responsibilities that ensure that the company complies with the Capital Markets Authority regulations. So not only do they do what we have talked about, these general duties, they also come back and make sure that the company is complying with the Capital Markets Authority. You remember we talked about insider trading in our last case, and the company secretary is to ensure that this company, the board of directors, whatever they are doing, does not expose the shareholders to losses, and neither does it enable one or two directors to make profits that are secretive. And for public companies, their regulatory reporting includes, again, compliance with the Capital Markets Authority and the National Nairobi Securities Exchange. They also make public announcements with shareholders and regulatory bodies. How do they relate with shareholders? They make sure that AGMs and EGMs and their rights are protected, their concerns are addressed. So for listed companies, while publicly traded, they have additional complexities due to the exposure to the public market. And these company secretaries for such companies will ensure timely filing and disclosures. They will also offer board training and support to the board of directors on governance issues and best practices. So for private companies in Kenya, which are not listed on the stock exchange, they still require effective governance. And company secretaries in private companies perform regulatory compliance, that is, they ensure adherence in the Companies Act. They also provide documentation, that is, they maintain company records, again, including the register of members. They file the necessary documents with the register of companies. They facilitate meetings and they draft resolutions and record these minutes. They provide advice on legal and regulatory matters that will affect the company. So in private companies, again, they ensure that they assist in the development and implementation of corporate strategies as well as business plan. And for risk management, whereby they identify and manage corporate risks. And these are legal and compliance risks. There's what the Companies Act requires every company to do: maintain registers, update the registers, ensure that you're having meetings, ensure that the board of directors only run the terms that are provided for in the articles of association. So the compliance is a must. And where the company does not do that and they face sanctions, it's the company secretary that advises on how best to make sure that these duties are complied with. So the company secretaries, we have talked about the registers, and these registers that they keep, they ensure that the names are properly recorded, the addresses, again, are properly recorded, and the shareholders and the change of shares, how many shares each individual or each corporate has. So how will a company secretary be liable? The company secretary is an officer of the company. And the aspect of fiduciary duties come into play. So the company secretary is required to act honestly and in good faith. Whatever they are doing must be for the benefit of that company. So one is personally liable to criminal charges if he or she commits wrongful acts, and they can be penalized with a fine. And a wrongful act can be as simple as failure to lodge the annual returns. We have talked about the compliance with the Companies Act. Part of the compliance is ensuring that annual returns are filed. So where this company secretary is unable to comply with that, that is a wrong based on law, and they are liable personally. And this is where they shall either be penalized with a fine or any other sanctions that may be made. In the event of liquidation of a company, the secretary, as an officer of the company, will be liable under Section 323 if he's been guilty of misfeasance. And again, he'll be liable to specific criminal penalties if he details or omits a wrongful act in respect of their statutory duties. So he can be made to pay a default fine if he fails to sign the annual return and the accompanying documents. And we have talked about their duties, the obligations to keep registers. So when they do not keep these registers, and the registers again must be open to the public during business hours, unless they are closed to enable the company to have the AGM and declare dividends. So for that, they're acting in accordance with the law. But where they do not keep the registers, and these registers are not available for inspection, then they have committed a wrong. It is their duty to maintain these registers. It is their duty to update these registers. And where they commit that wrong, Section 323 makes that company secretary individually liable. But with liability comes an indemnity, and this is provided for under Section 206, where the provisions in the articles or any contract that brought about this relationship, if the initial relationship is illegal, then they cannot be again liable for illegal acts. And this, then the court normally declares to what extent can you be indemnified from the actions where you did your actions in good faith, but these actions did not suffice. They were not enough. So they will look at your intention and the act that accompanied that intention, where you are keeping a register and the register was open to the inspection of the public within business hours. And if someone accuses you of not having the registers open, then the court will determine what are business hours in relation to the business that you're actually performing. Our business hours may not be the same, depending on the nature of work that we all do. So your indemnity, it will be determined by the law based on your actions and based on your intentions. Did you intend to cause harm to an individual? Did you intend to mislead the public by not keeping proper registers? Or was your act of not updating the register on time not intentional? So once that is determined, then you will either be held liable or you will have that indemnity that you're not liable for any wrongdoing. But remember, the wrongdoing must not be intentional. We have talked about those acts the company secretary cannot omit to do. They cannot omit to file annual returns. They cannot omit to update these registers. They cannot omit to advise the company. Their training is on ensuring compliance, regulatory. You remember our first sentence, ensuring compliance with statutory and regulatory requirements. and that the decisions of the board of directors, which again due to their fiduciary duties, are implemented and to ensure that the shareholders, they are protected. Them being the link between the board of directors and the shareholders, their duty is to ensure any decisions. Therefore, that is what we will cover with the company secretary. We have talked about their qualifications, their appointments. Section 179 will stipulate the minimum qualifications. What we have said, a member of a professional body, an advocate, and holds office as a secretary, assistant secretary for 3 out of 5 years. We have talked about their removal. And since they are appointed by directors on the terms, the directors may also remove the secretary. We will use the removal of the secretaries together in accordance with the contract signed, the Articles of Association, and the Companies Act. So we have essentially covered what a company secretary is, what their duties are, and this is the assignment regarding company secretaries.